now over to Dan, who is here, and Katherine as well, who are going to be talking about the Montreal Convention. Dan and Katherine, I think you all know extremely well. It's always difficult to avoid having a little peek at the directories. Dan, BAM1, of course, meticulous in his approach, hardworking, incredibly sharp, wonderful quote. Now, Katherine, who of course we know is in the Hall of Fame for the Legal 500, Liz Truss would like to have, I think, this next entry. Katherine Ellen is the standout always. Her team are devoted to her. She's extremely knowledgeable and sensible with excellent judgment. Expect no less. So over to you both. Thank you.
Okay, perfect. Well, hello, everyone. Very nice to see you all. Welcome to our talk on recent developments in Montreal Convention claims. Now, if you were to take that title literally, you'd be in for a really massive talk, but we're not going to quite cover all of the recent developments in Montreal Convention claims. We're going to focus on three, slide please, Hugh, on three important recent cases on the definition of accident for the purposes of Article 17. And the cases are Moore and British Airways, which is a decision of the US Court of Appeals, First Circuit, YL and Alten-Rhein Luftfahrt, CJEU case, and JR and Austrian Airlines, another CJEU case. And Katherine's going to talk about the first two, and then I'm going to talk about the last one. But before we go into the cases, a bit of sort of background and setting the scene, I think, is probably helpful on this topic. So fasten your seatbelts and put your items in the overhead lockers. I don't know, next slide, please, sorry. Now I'm going to go through this like a Concorde crossing the Atlantic, because I think we're all going to know this really, really well. Obviously, the Montreal Convention is the latest iteration in the Warsaw system of conventions, which had as its extremely laudable aim a development of uniform international code to apply to all international carriage by air contracts, and governing, amongst other things, the liability regime for death and personal injury caused in the course of international carriage by air. And you'd have to say that project started in the late 20s has been incredibly successful, in the sense that there are over 130 state parties to the Montreal Convention, which came into force in 2003 and in our legal system in 2004. Next slide, please. It's an exclusive regime. If you don't fall within, if you're bringing a claim arising from international carriage by air for death or personal injury, and you don't succeed pursuant to the liability regime, you can't fall back on the common law, as Sidhu's made very clear. It's amazing, actually, when you read the cases, just how many Montreal cases start out as claims in negligence or contract, how often it's overlooked. And I always think about Hone and Going Places, which is the famous, one of the most famous package travel cases of all time, which was about somebody going down the sort of emergency chute off a plane, and that should have been a Montreal case, but it wasn't. Not that seemed to matter in the end too much, but it's just very often overlooked, surprisingly. It's got its own jurisdiction regime, which I'm not going to go into, and it's, I think we all know, a strict 2-year time bar, which extinguishes the rights once you go past the 2 years. Now, the fact that it's an international treaty is important for our discussion because that has several consequences. The first being that the general domestic rules of statutory interpretation don't apply. Got to interpret the Montreal Convention in accordance with ordinary meaning in light of the object and purpose of the convention. And the courts can derive assistance from decisions of courts of other state parties. So it's one of those rare occasions where you find yourself going along to the county court or a high court brandishing a decision of the US Supreme Court, or perhaps even some other court from some other state in the US, trying to say that it supports your case. That obviously has consequences, that last point in particular for this topic, because the leading case on definition of accident is still the US Supreme Court decision in Sachs and Air France, which I'll come to shortly. And it also has the consequence that there is just an absolute plethora of cases from other jurisdictions on the topic. If you look in Shawcross and Beaumont, there are hundreds, of probably 1,000 cases on this topic from various jurisdictions. That's probably just the common law jurisdiction. So, that one of the consequences of it being this global instrument is that it generated an enormous amount of case law, and you can't just look at it purely through the lens of what our domestic courts have done with it. Next slide, please. So that brings us to the two-tiered liability regime. There's a form of strict liability up to the limit, which I think at the moment is, I calculate to be about £148,500 and contributory negligence is a defence. And once you get above that limit, the strict liability regime still applies, but you obviously, if you're the carrier, you have the possibility at least of escaping liability if you can prove the accident was caused not by your fault, it was wholly the fault of a third party, but the burden is on the carrier to do that. So that means that Article 17 is absolutely key provision, because Article 17 is the gateway, sets the gateway, provides the gateway, and sets the conditions for the strict liability regime under the convention. And central to Article 17 is the concept of accident. And what the article itself says is that, well, effectively, the condition for liability is that there has to have been an accident which caused the death or the injury. That's all that it says. Next slide, please, Hugh. So what constitutes an accident? Well, you don't get any help. There's no definition in the Montreal Convention itself. There's no definition or really any guidance in the Travaux Preparatoires either. It's obviously not straightforward as saying, well, what does an accident mean in common parlance? It's plainly a term of art. What you can take from the text itself is that the text clearly draws a distinction between the injury itself and the event causing the injury. So it's obviously not open to passenger to say that the injury itself is the accident. There obviously has to be something other than the injury causing the accident. And that you take that from the words, the accident which caused the death or the injury. So you can take that much from it. But beyond that, if you just look at the convention itself, you've got nothing to work with. So that brings us to the leading case, Sachs and Air France from 1985. And I mean, this is really the US Supreme Court providing a gloss on the convention. It has remarkably proved to be I'd say, but still the guiding light, still the leading case, and it has been followed in numerous other jurisdictions on this question. And I suppose it's only really chance that case happened to go to the US Supreme Court and happened to be considered by it, but it was. But like there's this kind of desire amongst courts, in all the state parties, to try and maintain some sort of consistency between their case law and that in other countries. So once the US Supreme Court sort of planted its foot down with this decision, there was then, I suppose, an understandable desire to follow it. But it's really only a matter of chance, I suppose, that this decision came out when it did and that it's been followed. And the facts were, I think, fairly well known. Valerie Sachs was landing, was a passenger in an aircraft landing in France. The depressurization or the change in air pressure as the plane landed caused her to go deaf in her left ear. And she wanted to claim that was an accident pursuant to Article 17, and she failed. The Supreme Court reasoning that it's only an accident if it's an unexpected or unusual event or happening that is external to the passenger. It was said that the air pressure changes in the cabin or injury arose from her own internal reaction to the air pressure changes in the cabin, which were the usual, normal, and expected operation of the aircraft. So they didn't fit those criteria. So it's just interesting, just pausing there for a moment to see how the distance between the wording in the convention and the formulation in Sachs, which posits the requirement that it be unexpected and unusual event and it's external to the passenger. Next slide, please. So SACS, as I say, has been applied in numerous countries, in particular in this jurisdiction. So in Morris and KLM, there was an accident. It was found. That was the case about one passenger sexually abusing another during the course of the flight. So I think that was a very straightforward application of the criteria there. It's clearly an unexpected, unusual event external to the passenger. I don't think we any argument about that one. But it's also applied in slightly more difficult situations. There's DVT litigation, which went to the Supreme Court, where it was held that the onset of DVT, again, was not an accident, because it was not an unexpected, unusual event external to the passenger, because it was simply normal cabin conditions. The Court of Appeal has also given two quite important decisions applying the AirSAC criteria. First, in Chowdhury in British Airways in 1997, that was the case about a claimant who had left-sided paralysis, nothing to do with the accident or the incident, that pre-existing, and he just simply fell when he tried to get up from his seat, and the Court of Appeal said, well, the accident there was caused by his internal condition and not by anything external to him. So there was no accident there. The Court of Appeal also considered the matter in Barclay and British Airways. So this is quite an important case, and we'll return to this when we look at the three more recent cases that we'll be looking at. But in Barclay and British Airways, the claimant basically just slipped on a strip, plastic strip, within the aircraft cabin, which all the evidence, or certainly the judge found, was just a standard fitment within the cabin in the aircraft. So there wasn't anything wrong with it as such. It was just a standard piece of standard fitment within the aircraft. And the Court of Appeal reiterated that the criteria in SACS applied, and found that there was no unusual or unexpected event that was external to the claimant in that case, hence no accident. And we'll come back to Barclay when we think about when we look at the other cases that are to follow and compare the treatment of that situation with the facts of the other cases. Over the page, please. But that's, what you can take from the treatment of SACS in the English cases, English and Welsh cases, is that there's been a very consistent application of the criteria in SACS. There's been no sort of wavering from applying the formulation that the US Supreme Court adopted to its full extent, and looking at each component of that and applying it. And in particular, the requirement that it be an external event, and that it be unusual and unforeseen. That's not to say that there aren't areas of where there's a lack of clarity, or that it's easy to apply the criteria in SACS, because it certainly isn't. In the case that Katherine's about to discuss more in British Airways, the court opens the appeal by saying that the words unusual and unexpected are words that often shadow dance with each other. And I think there's definitely something in that, because what is unusual and unexpected? It sort of sounds deceptively easy to say, but actually any given factual case, even on very straightforward facts, would be very, very difficult actually. It'll certainly be argued one way or the other. To what extent is it relevant to consider whether the carrier has been negligent or not? It's been said clearly by the courts that that's not the criterion, and that's a distraction. But quite often you see the courts sort of lapsing into, well, was there negligence on the part of the carrier in what occurred, in attempting to ascertain whether there's been an unusual or unexpected event. And another issue that's not totally cleared up, I don't think, in the English case law is, from whose perspective do you judge whether something is unusual or unexpected? Is it the passenger's perspective? Is it the carrier's perspective? And is it a subjective question, or is it objective? there's a dictum in Morris and KLM that to the effect that it's something that's to be judged from the passengers, in other words, the victim's perspective. Was it an unusual and unexpected event from their perspective? But you get very much a flavour in the English cases of, and not just in England but in other jurisdictions, of the courts taking into account whether something that's occurred or whether a piece of equipment or the setup, whether that's industry standard or not, whether it's usually done or not. And that's very much looking at matters from the carrier's perspective. So there's a certain uncertainty about what's the right approach, and that's something that Katherine's going to come on to shortly when she looks at one of the cases. Then there's also the difficulty in applying the test to facts, because sometimes it can depend on how broad the chain of events is that you have under consideration. So in Labardia, which was a High Court case in 2019, the claimant was walking down a mobile staircase. I mean, a lot of these cases about people falling up mobile staircases, it must be some of the most dangerous things on earth. Walking down a mobile staircase in Milan airport and slipping on the snow. And the High Court said, well, the snow was not an unusual or unexpected event. Now, I think from the carrier's perspective, well, no, it isn't, because, it happens all the time. We're used to it snowing on our staircase. But from the passenger's perspective, yeah, it is incredibly unusual and unexpected and pretty dangerous. So, I mean, I think that's quite a good illustration of how it really matters whose perspective you look at it from. So I think that sort of sets up, fairly briskly where we are with the law in this country anyway. Katherine, over to you.
Thanks, Dan. Next slide, please. Obviously, as we've already learned this afternoon, if we didn't know before, the Montreal Convention applies internationally, and so there is a real danger of differing interpretations of key terms like accident in the different national courts. I'm going to show my age here, but this picture of this fish, it's doing a Fleetwood Mac. It's going its own way. And there's lots of scope for that to happen in these cases when different courts are dealing with their own interpretations of the international treaty of the convention. Next slide, please. So we're going to look at the case of Moore, which involved a fall during a disembarkation using a mobile staircase. And I've tripped down a mobile staircase, not because there was anything wrong with it, just because I wasn't watching where I was going. But this one was slightly different because she was traveling on a British Airways flight from Boston to London, and she had a return flight booked back to Boston. The jet bridge that we normally walk down to get onto these planes, if we're in British Airways and not EasyJet, was broken, and therefore they had no choice but to use these portable stairs. And this staircase, that looks very nice and uniform, although I would worry about the gap at the bottom, wouldn't you? But all of the steps were of the same depth, apart from the very last one, which was a lot deeper. And when you walk down a staircase in any situation, you get used to the pattern, don't you? You get used to the pattern of walking down the steps and how far your feet are going to need to move down to get to the next step. And clearly what happened is this woman was a bit foxed by the fact that this last step was almost double the depth, and she fell, and she sustained some really nasty injuries to her ankle. Now, after she fell, a British Airways safety officer, obviously a reliable witness in the case, arrived at the scene and observed that the stairs were correctly positioned with a good grip. He testified that by walking up and down the stairs, he observed the last step was deeper than the other steps and noticeably slightly different. The cabin service director of the flight testified that everything had been serviceable and nothing abnormal had occurred with respect to the staircase. The plaintiff, as they're still called in the US, and her companion who she was traveling with, both said that there was no precipitation, there was no liquids, there was no rubbish on the steps that could have potentially caused the fall. So it had to be the change in depth that was responsible for her falling. Now, a formal inspection of the staircase revealed that it was working as it was intended to work. The plaintiff didn't really refute that, but she said the design of the staircase itself was defective. She said the last step, I'm not quite sure how she managed to measure these, but she gave evidence that the last step was 13 inches from the step to the ground, and all the other steps were 7.4 inches in height. I mean, she had a tape measure on her. I mean, that was really, really lucky. There was a report from an expert that explained that under the British standards, the maximum rise that people can be expected to negotiate was 8.7 inches. And so while most of the depths were within that parameter, obviously the last step clearly wasn't. But the expert also testified that that's guidance only and applied to staircases in buildings rather than to mobile staircases. So that didn't really get the claimant much further. So the issue in the case was whether the staircase with such a height difference in the last step was an inappropriate or unintended happenstance in the operation of the aircraft. And what happened is the British Airways applied for summary judgment, and that was given in favour of British Airways. They said it wasn't an accident, and the plaintiff's claim couldn't succeed. Now, obviously that was appealed, and it came before the Court of Appeals in the US, who, unsurprisingly, given that Sachs is also a US decision, looked at the Sachs decision to see what an accident, how to interpret accident. And this issue of perspective was looked at in quite some detail in the judgment. And obviously, British Airways' perspective was that the mobile staircase was operating perfectly normally, and everyone knew how to navigate these things. There was nothing wrong with it, and therefore it could not be an accident within the meaning of the convention. And the plaintiff's perspective was that this was dangerous, and that although she had navigated these things in other circumstances, she'd never faced a staircase with such a deep last step. Now, I think rightly, the court in this case said that the perspective that should be used when considering whether an accident has happened is that of a reasonable passenger with ordinary experience in commercial air travel. And I think that has to be right. I mean, that's perfectly sensible to me. And so they found that actually the court had not looked at that properly, and it's been referred back to be considered by a jury. Now, I haven't yet actually seen the next stage of that case. Whether we ever will or not, I don't know. But that's where we are. But definitely, the perspective is a subjective one, not an objective one, and that objective test is the reasonable passenger with ordinary experience in air travel. Next slide, please. So we're moving on to the case of YL, which is a decision of the CJEU. And this involves a slightly different set of circumstances because it involves a hard landing. I know when we all come into land, you all sit there, don't you, and think, how's this going to be? Am I going to feel this? Is it going to feel like I'm just gliding in? But we've all had, I'm sure, experiences of landings that are harder than others. Mine have all been with Ryanair, but there we go. On the 20th of March 2014, YL was travelling from Vienna on a flight operated by Alton Run. The name did make me include this, Luftfahrt. It's a lovely name. She claims to have suffered a spinal disc injury as a result of the landing. And during that landing, the evidence was that although it could be perceived by some as being a hard landing, it was still within the normal operating range of the aircraft. There was nothing unusual about it. Obviously, the first instance court, the Vienna Commercial Court, initially held that an exceptionally hard landing could be classified as an accident, but because this particular landing was within the normal operation of the aircraft, then that was not the case here, and gave judgment on behalf of the defendant. And the Austrian Supreme Court referred the case to the CJEU for a preliminary ruling, something that we will obviously never do again. Next slide, please. And the question was whether Article 17 had to be interpreted as meaning that the concept of accident covers a hard landing perceived by the relevant passenger as an unforeseen event, even though it's within the normal operating range of the aircraft. So again, the perspective comes back into this. Whose perspective are you looking at it from? And YL's view was that the landing was classified as hard and therefore had to be an accident, whereas the defendant's view was it was within the normal range and therefore not an accident. Next slide, please. The court decided that the ordinary meaning of the concept of accident is that of an unforeseen, harmful, and involuntary event. There's no reference to SACS in the judgment at all. It's not even considered. They referred to the previous case where they delivered a judgment, GN v ZU, and that's what that case said. So it had to be an unforeseen, harmful, and involuntary event. And they rejected completely that assessment should be based on the perspective of each individual passenger, because that could lead to what they said was a paradoxical result, because some passengers would have a perception that a landing was hard when other passengers might not. And therefore that was uncertain. And the whole thing about the convention is meant to avoid uncertainty. They also said that interpreting the concept of accident by reference to the individual perspective of each individual passenger could mean that the carrier would be at some detriment because it would extend that definition unfairly. And the whole point about the convention was that there had to be an equitable balance of interests between the passengers on the one hand, who obviously as consumers, the European Union wants to protect, but also the carriers on the other hand, who they want to encourage to have economic activity, provide a commercial service for the good of the economy. So therefore, the court found that a landing which does not exceed the limits laid down by the procedures applicable to the aircraft in question and which takes place in accordance with those procedures could not be regarded as unforeseen. And in this particular case as well, the particular airport that they were coming into was actually safer to have a harder landing because of the mountainous nature of the area around it. And so, unfortunately, the claimant lost. I'm going to hand over to Dan now to look at the last accident.
Yes, so the third case is JR and Austrian Airlines. So, the Austrians are at it again, and also the CJU as well. So in JR and Austrian Airlines, JR had flown from Greece to Vienna, and when she got there, she had an accident on a mobile staircase, and she slipped about 2/3 of the way down and broke her arm. And she brought a claim in the Austrian courts for about €5,000. And the circumstances were, and I think this is something probably be familiar to a lot of you, she was going down the mobile staircase with a bag in one hand and a 2-year-old child in the other. So she wasn't able to use the handrail that there was on both sides. Now, if you read the report, it's it's a sort of classic case of its kind in that JR and her husband made lots of allegations about the slippery surface and so on, and lots of factual allegations which were all denied by the carrier. Bottom line is what the Austrian court found as a fact was that there was nothing wrong essentially with the mobile staircase. It wasn't slippery. There was no defect with it, no damage. It was the only type that was available. And essentially, what was determined, there's no appeal from any of this, was that it wasn't possible to determine the reason for the fall, and that there wasn't any fault or negligence on the part of the carrier. She just fell. Essentially, next slide, please. And so there was a reference in due course to the CJU, and the main question that was asked essentially was, could these circumstances constitute an accident within the meaning of Article 17 of the Convention? And the answer to that was yes. And very much like in the YL case, the court reasoned very, very tersely, so you don't get much reasoning. So there wasn't any citation of Sachs either. And the court simply said an accident is an unforeseen, harmful and involuntary event. Okay, so the accident is an unforeseen, harmful and involuntary event. Doesn't require the damage to be due to any hazard associated with the aviation or operation of the aircraft. And it was also said that the objective of the convention, or one of the primary objectives, was ensuring the protection of consumers. Particular emphasis was placed on that. So that led the court to the conclusion that where, for no ascertainable reason, a passenger fall on a mobile stairway, that constituted an accident. Next slide, please, Hugh. Now, that's really interesting because, firstly, as I say, Sachs wasn't cited. I mean, it's not obviously binding on the CJU, but it is surprising that authority wasn't even cited. Even more surprising, given that the Advocate General had placed great emphasis on Sachs and other American and UK case law in their opinion. But what's really surprising about the decision, I suppose, is it's really difficult to point to any triggering external event. So what it looks like is the CJU has departed from the test in Sachs and effectively abandoned the requirement that there be some external event, certainly any unusual or unexpected one, which would be a major departure and a bit unexpected. It's very difficult also to reconcile Berkeley, for example, that we were looking at earlier with this decision. So in Berkeley, you'll recall the claimant slipped on the standard fitment within the aircraft cabin. There was found to be no defect, no particular slipperiness, no fault or anything of that nature, and that was said not to constitute an accident because there was nothing external. There was no external event, something unusual or unexpected. And this case is really, I think, on all fours because likewise, there's no external event, nothing unforeseen, nothing unexpected or unusual in it, and yet this EJ didn't have any difficulty finding that this was an accident. So what it looks like is that there's a divergence now growing between the approach that the CJU is taking to interpreting the Montreal Convention and the law under the Montreal Convention and other state parties, i.e. the US and the UK. It may be that in time that will be reconciled in some way. It may be that the CJU will come back round to looking at matters the way that the US and the UK and other jurisdictions do. difficult to predict, but it is difficult to avoid the conclusion that there is a divergence, and in theory there shouldn't be. It should be, as an international convention, should be interpreted identically across all the state parties. So I guess we'll just have to see what happens. But on any view, it's difficult to possible, I think, to reconcile with the English case law and with the US case law and with Sachs. So that brings us to the end of our three cases that we can analyse. Does anyone have any questions?